You are on bond for DWI and you've now picked up a new DWI. So you were charged again. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 24th, 2025, in Harris County, Texas, law enforcement officers were dispatched to a crash. The law enforcement officer spoke with a complaining witness who stated he had gone to the bathroom and heard the defendant crash into the bus. The complaining witness was the bus driver. The complaining witness estimated the damages to be $1,000. Another witness saw the defendant strike the bus, get stuck between the bus and another vehicle, and then exit the driver's side door and try to push the vehicle out. The witness stated after another individual told the defendant they were calling the police, the defendant fled. Another law enforcement officer was alerted to the incident and found the defendant, who matched the description given. A witness was able to identify the defendant as the individual driving the vehicle that struck the bus. Another law enforcement officer made contact with the defendant, who stated he was coming from an Astros game where he drank. The law enforcement officer observed a moderate odor of alcoholic beverage, glossy eyes, and profuse sweat from the defendant. The defendant refused to cooperate on standard field sobriety tests. The defendant refused to provide a specimen. A blood warrant was obtained and executed.
Mr. Gallegos, I'm going to find that there's sufficient probable cause to go forward with the case. I am now taking away your privilege to drive. You are not allowed to drive at all. Do you understand me?
Yes, sir.
On one ankle, I'm going to put a scram monitor so I know that you're not consuming alcohol. On your other ankle, you will get a GPS monitor, and I'm giving you a curfew because I don't want you out in the middle of the night. And if I find that you're out, I will revoke your bond and make it extremely high. He's on bond for this DWI.
Yes,
I'm
sir.
revoking his bond. You're going to jail today.
Right now?
Right now.
Okay, as far as the monitors, can we
So-
waive the fee?
Absolutely, of course.
Can you give my stuff to my mom?
Yes.
So these are conditions. We'll have him sign now. The GPS monitor prior to release.
Are you setting the bond?
Of course. Mr. Gallegos, I want you to understand something. This is an affidavit that you're going to sign to me, that you're going to promise to me you're not going to drive. I don't give a rat's behind what your excuse is. If Jesus comes from heaven and needed to ride to church, you drive. I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand? I am now also sending notice to DPS that I'm placing a restriction on, you're not allowed to drive, but I'm placing an additional restriction on your license that you are not allowed to drive any vehicle that doesn't have an ignition interlock on it. This notice is sent to DPS so that every single officer in the state knows that if you are in a vehicle driving, they pull you over, you don't have an interlock, they will take you to jail. Do you understand? As it stands, you are not allowed to drive for any reason. Okay, we'll have him sign this. We'll put him in back. I'll set the bond and then,
Take my card, yeah, and
Look, I asked you to stop moving around. We'll handle this when I can get the.
All right, Judge.
get whatever date you want on the new cases.
Okay.
When he posts bond on the, old case, feel free to get in touch with the, and then
Okay.
you could put the date
Just
or
one
whatever.
together.
Yeah,
What are
He-
you setting the bond at? I'll tell it.
5,001.
5,001.
Yeah.
both cases or just legal?
He just, no. The two new ones, I'm not gonna touch. I'm gonna leave it as is. He's made a bond, so we're only gonna do the old DWI, 5,001. Actually, we're gonna need, he signed conditions now, so when he gets out, he'll have, yeah,
Okay.
because we'll give him a copy of the conditions now.
Okay,
So they just feel free to let her, whatever date you get,
okay.
after
And
he
then
gets out,
once
just
it's
get, yeah.
Okay.
Hi,
I'm here for Francisco Hernandez.
Okay.
He's here for a bond violation.
okay, come up, Mr. Hernandez. It's Hernandez or
Mr.
Roxanne? What the rules?
Presumptive positive for THC.
That's it.
That's it.
Okay. I'm giving you a pass for 50 days from the time that we ordered you not to use. Don't use. Do you understand? So we ordered him not to use when? He's still testing positive. We ordered him not to use in January.
He tested positive on April 7th, Judge, or not, on April 14th, rather.
Okay, but he's still testing positive. He's still using when we ordered him not to use.
Yes, Judge, but I understand that THC can take up to 30 days to work out of urine, so there's no evidence that he's been using beyond the,
I ordered him not, let me see, hold on. I ordered him not to use in January. We are now,
yes, Judge, but you've already addressed his drug use that resulted in the positive result on the April 14th drug test. You addressed that by chastising him in court and issuing several additional bond conditions. There's been no evidence that there's been any additional drug use for the court to address.
if I tested him in early January, then I'm gonna have an issue. But if it's the first time I tested him was in April, then I'm gonna give him the 50 days from the first time that we tested. But if I tested him early on and he tested positive and I admonished him not to use and he's still testing positive, I'm gonna have an issue. I don't remember when the first time we tested him, so I'm gonna ask her. Roxanne, on Mr. Hernandez, when was the first time we tested him, please?
When he first tested positive for THC?
Yeah, when did we first test him?
Oh, it was March 11th of this year.
So March 11th was the first test and that was positive for,
Negative.
that was negative.
Yes, it was negative. And then on April 7th is when he was a no-show. And on April 14th, it was confirmed by lab that he was positive. for
No,
THC.
you're using. I'm sorry. I'm revoking your bond. You're going into custody.
I could just ask the court Mr. Hernandez's mother is out in the hallway. I'm certain that she's going to pay whatever the bond is. This, revoking the bond here will only have the effect of punishing, his mother who will have to pay the bond. And I'd also just ask the judge, you to consider that I understand that there may be evidence that he's used since he was ordered to not use. I understand that. But there's no evidence that he's using now or that he has used in the more than 2 weeks since the prior drug test.
We just tested him yesterday. He tested positive. He tested positive a week ago. I've ordered him not to use. I mean, if I don't, then I'm rewarding him for his behavior, Mr. Schlossberg. That doesn't make any sense. You know, I understand that it's punishing mom. These are the things that you need to consider when you're out there. I told you not to use, and you're now using. Goes with you. I'm sorry, Mr. Schlossberg. I can't just continue to let people go.
Judge, the drug test yesterday, it came back positive for THC because it was within 14 days of the.
This is what judges mean by zero tolerance. Once a bond condition is violated, everything changes. Freedom turns into custody instantly. Judges see this as defiance, not a mistake. Be honest, should second chances exist after a clear court order is ignored?
Previous drug test on the 14th.
He tested negative the first time we tested him, and now he tested positive for using marijuana. That's it. There's no, I mean, really. If I don't, I'm enabling the behavior, and that's it.
Yes, Judge. Maybe excuse me.
Please. Good morning, Mr. Galvan. You were charged with driving while intoxicated. You were facing up to 6 months in jail and or a $2,000 fine. Do you understand? Are you sure, or would you?
He's just a little bit embarrassed of the situation, Judge, of being here for the first time.
Do you prefer a translator or?
Well, I understand what you just telling me, yes.
Okay, we are going to do probable cause. We need to know what happened in the case. You have the right to remain silent. Anything you say can or will be used against you. Okay, ready?
Yes, Your Honor, thank you. On April 27, 2025, in Harris County, Texas, a law enforcement officer observed a vehicle going 74 miles per hour in a 45 mile per hour zone via radar. He observed the vehicle stop beyond the designated stopping point at a red light and make a wide right turn. The law enforcement officer initiated a traffic stop and observed the defendant to be the sole occupant of the vehicle. The law enforcement officer observed watery, bloodshot eyes, slurred speech, and a strong odor of alcoholic beverage. The defendant swayed while standing in place. The defendant's family showed up and stated they drove him home because he was drunk, and they found out he left again, so they went to the location of the stop. Standard field sobriety tests were conducted. A 6 out of 6 was reported on the HGN, a 3 out of 8 on the walk and turn, a 3 out of 4 on the one-leg stand. The defendant refused consent to provide a specimen, and a blood warrant was obtained and executed.
Any DWIs? Does he have a license?
He does have a license, John.
No prior DWIs, Your Honor. I'm running his license, although.
Mr. Galvan, I'm going to find that there's sufficient probable cause to go forward with your case. Hay suficiente causa para continuar con tu causa, ¿ok? No puedes tomar alcohol, illegal drogas, y te voy a hacer examen. Si tomas o si usas, te pongo en la cárcel. ¿Me entiendes? Tú tienes un abogado, no tienes que venir a la corte hasta que él te dice. Pero si él me dice que no puede contactar y tienes problemas, voy a revocar la fianza. ¿Me entiendes? Tú no puedes manejar si no tienes una licencia y también aseguranza en tu nombre. All right?
Thank you, Your Honor.
So for now, we will have you sign a reset. Vas a ir con Roxanne de Pretrial Services y ya te puedes ir.
Y no se tiene que presentar para próximas cortes.
Muchas gracias.
Gracias.
You are Joe Castillo. Jose Castillo.
So, Jose,
Castillo, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 23rd, 2025, in Harris County, Texas, a law enforcement officer observed a vehicle going 77 miles per hour in a 35 mile per hour zone via radar detection and weave in and out of lanes around 4 vehicles, nearly causing a crash. The law enforcement officer briefly lost sight of the vehicle, but found the vehicle parked sideways in a driveway close by. The defendant was still inside the vehicle and admitted to being the driver, but stated he was only going 60 miles per hour.
Okay. Mr. Castillo, I'm going to find that there's sufficient probable cause to go forward with the case. You run his license, please.
Yes, Your Honor.
You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. Do you understand? That is a condition of your bond. I'm now also ordering you not to drive in a reckless manner, not to participate in any street takeovers, racing, anything of this nature. And if I find you do, I will put you in jail. No more PR bonds. Do you understand?
It's other way, Your Honor.
How old are you, sir? What do you do for a living?
I work in a warehouse.
Okay. Do you have the ability to hire a lawyer? Do you want a court-appointed lawyer?
I'm gonna request a attorney.
Okay. I need you to fill out an application for me. Deputy Miranda is going to give an application. I'm going to have you go to Victoria, sign a reset, and then I'm going to have you take a seat in the jury box. Do not leave until you sign all our bond conditions. You understand? Come on. Do you mind filing those conditions, please?
Yes, Your Honor. There'd be no reckless driving and no driving.
Same
without a
as-
valid license.
And then, no racing, street takeovers, donuts.
Yes, Your Honor.
You are Alexa Mendoza. Ms. Mendoza, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Thank you, Your Honor. On April 23rd, 2025, law enforcement officers were dispatched to a traffic collision in Harris County, Texas. The officer observed the defendant's motor vehicle on the fixed rail tracks impaled to the LRV. The law enforcement officer opened the door to check on the defendant, the sole occupant of the vehicle, and observed the defendant to be impaired. The law enforcement officer observed glossy eyes and slurred speech, and the defendant stated she left a bar where she had 8 to 10 drinks of tequila and was on the way to a concert. Standard field sobriety tests were conducted. A 6 out of 6 was reported on the HGN. The law enforcement officer notes that the defendant threw up during the HGN. The walk and turn was a 4 out of 8, and the one leg stand was a 3 out of 4. The defendant was ID'd by her Texas driver's license, and the defendant consented to a breath test yielding a .137 and a .123.
Any prior DWIs?
No, Your Honor.
License?
Check that.
Ms. Mendoza, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. You will be randomly tested. If you test positive, your bond will be revoked. You'll go into custody. You understand?
Yes.
You are not allowed to drive unless you have a Texas driver license and liability insurance in your name. As long as you have those, you may continue to drive. Just don't use. Do you understand?
Yes, sir.
It is helpful, Your Honor.
Great. Because you have a lawyer, I will waive your appearance, but you must stay in touch with them and they'll tell you if and when you have to come back to court. For now, we'll have you go to Victoria, sign a reset. You'll get with Roxanne for your bond conditions and then you're free to go.
Yes, sir. Thank you.
Thank you. Good morning, Mr. Royalty.
Yes, sir.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 24th, 2025, a law enforcement officer was dispatched to a Shell gas station in Harris County, Texas. Upon arrival, the officer observed the motor vehicle to have crash damage and to be disabled and inoperable. The law enforcement officer observed the defendant sitting in the driver's seat. The law enforcement officer observed constricted pupils, slow speech, and unsteady balance. The defendant stated that he was driving his vehicle before the accident and that he does not know what he wrecked into. The defendant stated he did not know where he was coming from before the crash. The defendant stated he consumed one alcoholic beverage. He also stated that he inhaled nitrous oxide approximately 20 minutes before the crash. Standard field sobriety tests were conducted. A 0 out of 6 was recorded on the HGN, a 3 out of 8 on the walk and turn, a 2 out of 4 on the one-leg stand. The law enforcement officer observed an empty bottle of vodka on the driver's side floorboard, an empty vodka bottle inside the center console, and a half-empty beer in the back seat. The law enforcement officer observed 3.3 liters of space gas containers of nitrous oxide and 14 1-liter nitrous oxide containers. The defendant is the registered owner of the motor vehicle. The defendant agreed to a breath test strip. However, the law enforcement officer notes that there was an interferent error and the breath test was unable to be collected. The law enforcement officer called for a drug recognition expert who completed an evaluation. The drug recognition expert stated the defendant is under the influence of cannabis and is unable to operate a motor vehicle safely. The defendant consented to a blood test and a sample was collected.
Okay. Mr. Royalty, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication, and that includes nitrous oxide, whippets, anything of this nature. Do you understand?
Yes, sir.
If I find that you use, I will revoke your bond, put you in jail, no more PR bonds. Any prior DWIs?
No priority to
License?
eligible.
And you may continue to drive as long as you have a license and liability insurance in your name. If you don't have either, then you're not allowed to drive. Do you understand?
Yes, sir.
Do you have the ability to hire a lawyer?
Yes, sir.
Okay. I can have you fill out an application. We'll take a look to see whether you qualify. I need to know everything about you, how much money you have at the bank, what you do for a living, what kind of car you drive, how much money you have coming in, and I'll take a look to see whether you qualify. Deputy Miranda is going to give you the application. I'll have you sign a receipt with Victoria, and then we'll have you take a seat in the jury box, sir. Sir, please. Why does this keep happening? Over and over and over. Why does this keep happening? How many cases did you have last year, Mr. Addison?
I have quite a few, sir.
Now it pled on the 17th of December, and not 3 weeks later, you have now another criminal trespass. How do we stop this from happening?
You need to leave Texas?
No, we don't want you to leave Texas, but we want this to stop happening. Why would I keep doing this?
Officers don't like me out there, man. They be harassing me. They beat me up. They assaulted me. They put me in the hospital. They tried to kill me.
So why go back?
What do you mean?
Why go back to the same location over and over if you know that they're going to beat you up?
I'm of the state of Texas, not just this area, the state of Texas, the laws don't like me, the police don't like me, sir.
That's baloney because you're a likable guy. We all like you, Mr. Addison. You seem like a stand-up guy, you're nice, but you keep going back. Why would I keep doing this? You know, we hit you with the time served, we let you out, 2 weeks later you pick up a new case. And it's been like that for the last damn year. Where's your family? Who do you have in your life?
I don't have nobody in my life, sir. All my family is dead. My twin just died not too long ago.
You ain't got no kids?
But they grown, yeah, but I can't find them.
Why not?
Because their mother hid them from me.
You ever tried to find them?
Yes,
How?
through the internet. Through the internet, sir.
I don't know, Lori. We're doing the same shots over and over and over. And last year, 1, 2, 3, 4, 5, 6, 7, 8, 9 cases just last year. You pled at the end of December. January, you've got a new case. We let you out. You took off on us 2 more times. And the only reason we have you now is because you picked up an interference. And now we're doing the same thing over. I'm not going to do this. I'm done, Mr. Addison. I'm not going to continue to do this. Plead you to the time served in hopes that you're going to go out there and not do it. No, it's not going to happen. We need to figure something else out. Thank you. That's very sweet. But I'm not going to do this. We need to do what I'm going to do now, what's called a TRAS, to see how we go forward. Because I don't know enough about you and what's going on in your life to figure out how we go forward so you stop picking up criminal cases. I told you that many moons ago that I'm going to stop doing this. And now is the time. I'm not doing it, Mr. Addison. We will set this case for a TRAS. I'm going to try to expedite to get it done as fast as we can. I'm done. What I'd like to do, and the hope is that somehow you, me, and Lori can figure out what kind of family you have in the United States so that we can get you somewhere where you stop getting in trouble. But it's not working what we're doing. And I'm not going to continue to, this is not a revolving door. Do you understand, sir?
Yes, yes, Your Honor.
That's what we're going to do. So Lori, I'm sorry, but let's set it for a TRAS and we'll come back next week. Lori, Mr. Bueno, Lori, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement. They're offering you 3 days in jail, credit for the 2 days that you've done. You need to understand that this charge is going on your record. It will be there for the rest of your life. Next time you get pulled over, if you have any kind of funky smell, it's probably not going to go well for you because the first thing officers do, they look at your record. You understand?
Yes, sir.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you plead guilty, you can never change it. So you didn't want to do PTI.
Judge, we discussed it and he couldn't get the character letters together and.
It's a damn shame, Mr. Bueno, because I'm going to tell you, you had the ability to get this thing dismissed. Now you're pleading guilty to this. One day you're going to look back and say, why didn't I take the time to get it done? This will affect you for the rest of your life.
It's possible.
I'm not, no, you're now at 200 days. You've done nothing. No, you've had plenty of time to get it done, not on the day of when you're set to plead. The other thing is this, Mr. Bueno, I'm going to tell you that if you come back here with another DWI, it is a minimum of 30 days in jail for anything that you pick up. Not only that, if you continue to endanger the community, a second DWI, it's a $6,000 surcharge. So get ready. If you want to get lit, take find another way, Uber, Lyft, whatever it may be. How do you plead to the offense? Guilty or not guilty?
Yes, sir.
I'm going to find you guilty. I will send it to you to the agreement. I'm going to suspend your license for 90 days.
Good morning, Judge.
You need to do this ahead of time. It's a pre-signed waiver, Judge. She already has a copy. I sent her by email.
Got it. Okay.
It's only because he was
Be here now.
he's in the holdover. Yes, Judge.
Have you explained this to him?
So I explained it last time, Your Honor. I tried calling the holdover today because we were under the understanding that he had signed a waiver aside from that one. But if he can step out so he can understand what's going, because I know last time he was.
Please. Do you know the name? Okay. Morning, Mr. Groves.
Morning.
I'm bringing you out just to give you an update of what's going on with your case. You were wanted out of the state of Ohio for a probation violation for I'm assuming that's weapons under disability.
Yes, I'm not familiar with the charge. I don't know what the Texas equivalent is.
The thing is this, Mr. Groves, is that when you sign for probation, no matter where you are, you need to read the fine print. Many times when you sign, you waive extradition by virtue of signing the agreement by saying, hey, if I ever take off, I will refuse to fight extradition. And that's what's happening now. So even if I wanted to give you a bond so you could go turn yourself into Ohio, I can't because you have already waived by virtue of signing for the probation. You understand? So that means that we give the demanding jurisdiction, which is Ohio here, 30 days to come get you. Okay? Okay?
Thank you, Judge.
All right.
Thanks. Thank you, Your Honor. Maybe.
This warning isn't dramatic. It's real law. Texas now allows vehicles used in street racing to be seized as instruments of a crime. Translation, this isn't just about tickets anymore. It's about losing your car forever. Would that stop you from racing, or do people only learn after it's too late?
Times.
Good morning.
Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
Thank you, Your Honor. Sorry, I'm having trouble loading it. Okay, here we go. On April 23rd, 2025, in Harris County, Texas, law enforcement officers were dispatched to a suicide. Upon arrival, law enforcement officers found the defendant in the driver's seat of a U-Haul truck, slumped over the steering wheel. The law enforcement officer observed bloodshot eyes, slurred speech, and unbalance from the defendant. The passenger, the co-defendant, was detained and a crack pipe fell out of the co-defendant's pocket. The law enforcement officers found foil with narcotics residue on the passenger seat of the vehicle. The defendant admitted to taking Xanax that morning and standard field sobriety tests were conducted. A 6 out of 6 was recorded on the HGN, a 2 out of 8 on the walk and turn, a 0 out of 4 on the one-leg stand. The defendant consented to a blood test. A wheel witness stated they saw the U-Haul in motion, pull into the driveway of a house across the street, and then walked over to the U-Haul and saw the defendant in the driver's seat.
You said they did field sobriety tests? They take them to the station? What?
Yes, Your Honor. Standard field sobriety tests were conducted. 6 out of 6 on the HGN, 2 out of 8 on the walk and turn, and a 0 out of 4 on the one-legged stand.
Blood test, breath test?
It was a consensual blood test.
Any prior to the eyes?
No, Your Honor.
Signs I'm going to find that there's sufficient probable cause to go forward with the case. I don't know if you have a problem with drugs or alcohol. Now is the time for you to address it because I'm telling you, if it becomes a problem while you're on bond, I'm going to address it for you. And I promise you're not going to like the way that I do it. Do you understand?
Yes, sir.
I'm ordering you not to use alcohol, illegal drugs, unprescribed controlled medication. I'm going to test you and I'm going to test you probably within a week. Do you understand?
Yes, sir.
Do not use. If you have a problem, now is the time for you to do whatever you need to do to address it. You have the ability to hire a lawyer, ma'am.
No, I don't think so.
Okay, I need you to fill out an application for me and I'll take a look to see whether you qualify. I will have you go, oh, you said she has a valid license?
It is eligible.
Okay, you're also not allowed to drive unless you have valid liability insurance in your name, and that is also a condition of your bond. Do you understand, ma'am?
Yes, sir.
So I'm gonna have you go to Victoria, sign a reset. Deputy Miranda is gonna give you an application. I need you to fill it out for me. When you're done, you can bring it back to us and we'll take a look. Please.
Your Honor, I'm here on a plea this morning for Jose Traconis.
Okay, are you ready?
Yes, Your Honor.
Do you mind bringing them up? Good morning, Mr. Traconis. You speak English, right?
Yes.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement. They're offering you 3 days in jail, credit for the 2 days that you've done. You need to understand that this charge will go on your record. It's going to be there for the rest of your life. The next time you get pulled over, you smell like alcohol or dope. An officer's going to see this DWI. It's probably not going to go well for you. So don't give him the ammunition. Don't get into a car, even if you've had a sit. Do you understand?
I understand.
Bring up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization, you give up the right to appeal. Once you plead guilty, there's no change in this. Is this what you want to do?
Yes.
How do you plead to the offense, guilty or not guilty?
Guilty.
Mr. Traconis, I want you to understand that from now on, what we're doing today, you're facing a minimum of 30 days in jail from now on if you ever pick up another DWI, not to mention a $6,000 surcharge that tax on you. And if you don't pay it every day or every $100 you owe, you sit 1 day in jail. Do you understand?
Yes, sir.
Okay. I'm going to suspend your license for 90 days. Do not drive until you get a license. Good luck to you, sir.
Your Honor, just if I may mention, I just wanted to notify the court that we will be applying for
Occupational? Okay. Sure. Okay. I understand that you're going to have to, when you apply for an occupational license, you will have to do treatment. So, what we normally do is we have you do a TRAS, and then whatever the TRAS says is what you end up doing, and you have to get an interlock. So I don't know whether probation is something that you want, where I don't suspend your license, or whether you just want to do this, because you're going to undergo basically probation-esque terms regardless, if we give you an occupation. So, okay?
Yes, sir.
Okay, all right, good luck. Good morning, is it Haran?
It's Aaron.
Heron? Ms. Heron, you're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Thank you, Judge. This one was a 2B. On September 28th, 2024, a law enforcement officer was dispatched to a family disturbance at a residence in Harris County, Texas. The caller reported she observed the couple arguing in a truck, children crying, and heard a loud bang as if someone got struck in the head. The law enforcement officer observed the truck with one functioning headlight, matching the description that was given him regarding the truck. The law enforcement officer observed a juvenile outside of the truck with red puffy eyes. The law enforcement officer made contact with defendant 1, Ms. Heron, and defendant 2. The defendant stated there was no altercation or arguments that occurred, and that the law enforcement officer was talking to the wrong people and that they were okay. The law enforcement observed an odor of marijuana. The defendant's vehicle was sitting outside of a random residence at night, and the defendant stated the vehicle belonged to a friend.
Which defendant? Who?
I just said the defendant stated the vehicle belonged to a friend, and then there's defendant 1, which is referring to Ms. Heron for the next sentence. Ms. Heron refused to ID herself and stated she was going inside of the house. The law enforcement officer told defendant 1, Ms. Heron, to stay put until the conclusion of the domestic violence investigation. Defendant 2 exited the vehicle, stated, "No, I am not," when advised, and he was detained and pulled up his pants before getting in a bladed stance. The law enforcement officer grabbed the defendant 2's right wrist. Defendant 2 pulled away. The law enforcement officer grabbed defendant 2's shirt, telling him to stop as they fell to the ground. The defendant 1, Ms. Heron, pulled the law enforcement officer's arm and pushed the law enforcement officer's chest, preventing the law enforcement officer from restraining defendant 2. The law enforcement officer took out an electrical conducted weapon, told defendant 1 to get out of the way, Ms. Heron, and defendant 1 continued to refuse and push law enforcement officer's chest. Ms. Heron ID'd herself with her name and date of birth, which was confirmed with the Texas driver's license.
Ms. Heron, don't. Now's not the time. I've got a bunch of DAs here. Whatever you say, they're going to use it against you. You will have the opportunity to fight your case. Just now's not the time. I'm going to find that there's sufficient probable cause to go forward with the case. Do you have the ability to hire a lawyer, ma'am?
I don't.
Okay, we can have you fill out an application. I'll take a look to see whether you qualify. I need to know everything about you, how much money you make, what kind of job you have, and then we'll take a look to see whether you qualify. I see that the co-defendant in this case has a valid warrant for his arrest. I think that there's still a warrant open for his arrest. Also on a felony warrant as well. I'm ordering you as a condition of your bond not to have any contact with the co-defendant in this case. Do you understand? If you do, I'm going to put you in jail. No more PR bonds for you. Do you understand? Okay. So Deputy Miranda is going to give you an application. I'm going to have you go to Victoria, sign and reset, and then we'll have you take your seat in the jury box while you fill it out. Okay? Please.
This is a huge legal turning point. Once the alleged victim is a minor, the stakes rise immediately. Even if tempers were flaring on both sides, adults are held to a completely different standard under the law. Here's the question for you. Should frustration ever justify physical force against a teenager?
Are you Caroline Pomeroy? Ms. Pomeroy, you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. Okay.
On June 1st, 2024, officers were dispatched to a disturbance call. A group of drunk adults were upset at some kids who had sped through their residence or by the residence in a gated community. Officers made contact with the juveniles, the complainant witnesses, who lived approximately 9 houses down from where the adults lived. All the juveniles were aged 16. The complaining witnesses reported to officers that when they arrived at their home, 2 adult females, including the defendant and an adult male, ran towards the complaining witness. The complaining witness told the witness, who was the driver of the car, to drive around the block. So they got back into the car. Before they took off, the defendant threw an empty seltzer can at the vehicle, hitting it. The complaining witness and the driver exited the car.
They threw empty seltzer cans at
the teenagers.
At the car that was speeding.
Okay.
Complaining witness and the driver of the car, also juvenile, exited the car to assess damages and see why the adults were chasing them. The defendant approached the complaining witness, accused him of not living in the neighborhood, and accused him of staying at an Airbnb. Complaining witness informed the defendant that he was a minor. The complaining witness then walked back to his residence when he was punched in the back of the head by the defendant, causing dizziness, pain, a visible bump. He indicated to the officer that it was a 7 of 10 on the pain scale. The defendant and an adult male then chased the complaining witness, talked to them by flinching at them. The complaining witness picked up a brick for protection and got to a neighbor's house and sought help. The defendant then came to the complaining witness's house, rang the doorbell, and was screaming for the kids to come outside.
All of which we dispute with the exception of a few facts.
Okay, so you'll get the opportunity to fight your case, obviously. So, Ms. Pomeroy, the only thing I'm going to advise you now is that I'm going to put bond conditions on you. I am going to find that there's probable cause. I'm ordering you not to have any contact with these complaining witnesses and not to be in possession of weapons. That's it.
Is that, Your Honor? Sure. This, not included in the probable cause was your complaining witness coming up to my client prior to anything happening before them, because first of all, when they were motioning them to slow down in this gated community, they were driving 40 miles an hour through. The complaining witness stuck his head out the car and said, "Go, may I use profanity, Your Honor?"
Sure.
Fuck yourselves.
Sure.
My client, because of that, threw the empty seltzer can, causing no damage. The complainant approached her, accosted her, bumped into her, and said, "I'll fucking kill you and your fucking family." For those reasons,
A reasonable response would be,
I'm not talking about, I mean, we'll get to the guilt or innocence, so she has a right to defend herself when she's run into. But you're right.
Sticks and stones.
I dare, he ran into her, Your Honor, made physical contact. But that's not the point of what I'm saying. I agree, we can litigate all this later. I have a real problem with her being ordered, although she doesn't own any handguns or weapons. Her husband does. This guy has threatened to kill her and her effing family. I would ask that bond condition, I don't care if it's on her, but that they not be forced to remove all weapons from their home.
well, I'm just ordering her not to be in possession.
Okay, that's fine.
Right.
That's
I
fine.
mean,
As long
the
as
husband didn't get charged,
household
correct?
can be- Yes.
She's the only one that's charged. I don't have any jurisdiction over the husband. You know, for future reference, call the cops, you know? I mean, I think that, you know, they're 16-year-olds, all 16-year-olds act like what? Right, like a bunch of a-holes, right? I have nearly one, I'm just waiting for when he starts acting like this as well.
I'm racing too.
You know, right. But for future reference, right. So the only thing I'm going to ask you to do is don't have any contact with these kids. Don't go near them. Chances are, if they were renting an Airbnb, they're probably gone.
They weren't, Your Honor. It turns out there is a house on the street that's rented out to the outrage of the entire community.
So
He actually lives with his aunt way down the street. My client didn't know that. That's why she asked the question. The only other thing, and I'm sure you'll tell me it's okay for me to have contact with the complainant. I don't really want contact with him other than to give them a no trespassing warning to not come to their house.
Yeah, just be careful because remember, they're 16-year-olds. So when you try to go there, and I'm assuming they're just going to try to butt heads with you like Billy Goat.
I know
So
how to be careful. We actually asked the constable to deliver them. For whatever reason, they declined.
if you get one that declines, go to the next one. Just keep going until someone, you know, at some point you'll get to someone that responds. If one constable says no, just go right up the chain and just keep calling until someone does, right? At some point they will. And just tell them that, you know, we really have a problem with speeding and this kind of problem in the neighborhood, and hopefully someone will listen. Hopefully. So the only other thing that I'm going to advise is that I'm hoping that there's another way out of this subdivision, right?
She lives beyond them, so yes, she goes another way up.
Right. So, you know, I would just try to maintain, because if they call and say, hey, she's harassing me again, what's going to happen? Right. Okay. And I believe it. So for now, I am going to find probable cause. Like I said, you have a lawyer. Because you have a lawyer, I will waive your appearance. You don't have to waste your time to come into court, but you must stay in touch with counsel. He will tell you if and when you have to come back to court. I will have you go to Victoria Center, reset. After that, we'll just have you take your seat in the jury box. We'll get your bond conditions, and after that, you'll be free to go after you sign it. Okay?
Thank you, Your Honor.
Thank you, sir. Luis Fuentes.
Yes, sir.
Mr. Fuentes, you're charged with racing on a highway. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Judge, I'm sorry, there's a co-defendant that's here also.
Oh, wonderful.
39 Salazar, come on up. There's a third co-defendant also.
Really?
So Salazar's on 39.
Okay.
And age 48, Barilla.
Wait, what's the last name? You were Julio Salazar.
Right.
And you are Joe Alexis Varela. All of you guys are charged with racing on the highway. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, gentlemen. You have the right to have an attorney present. If you cannot afford one will be appointed to you guys. Okay.
On July 2nd, 2024, at approximately 11:50 in the evening, officers observed a black Camaro line up with a blue Mazda and a silver Acura. All three of these vehicles were observed conducting a roll race in which the three vehicles slowed down to match speeds, lined up in lanes 2, 3, and 4 before accelerating at a high rate of speed in an effort to outpace each other in a competitive manner. Officers in unmarked cars were able to maintain visual on the vehicles until marked units could move in to conduct the traffic fix stops. Defendant Fuentes was the driver and sole occupant of the silver Acura. Defendant Salazar was the driver and sole occupant of the black Camaro. And Roma was the driver and sole occupant of the blue Mazda.
Do we know what kind of speeds they went at?
It doesn't say if they were on the Passes Street.
That was recorded, Judge, but they weren't clocked.
Say that again?
They recorded officer recorded on their cell phone, but they weren't clocked because they didn't have a start detector.
So we have three basically become stationary and then boom, go.
They lined up with each other at the same rolling speed, and then they
and then take off.
Distance each other.
Got it. Okay, Mr. Fuentes, Mr. Salazar, Mr. Varela, I'm going to find that there's probable cause to go forward on all of your cases. Do you have a Texas driver license, Mr. Salazar?
Oh,
I'm sorry, Mr. Fuentes, do you have a Texas driver license? Mr. Salazar, do you have a Texas driver license? Do you have a Texas driver license? Okay, I'm going to tell you now that the Texas legislature, as of last year, made it extremely easy for those who get busted with racing to take your cars away from you, seize it permanently, and take it as fruit of a crime, and you there forfeit that vehicle forever. So you are now on notice. If it continues to happen, at some point, you're going to get an officer that's really going to be gung-ho, and they will take and seize your car from you permanently. Mr. Fuentes, I'm now making it a condition of your bond for you not to participate in any racing, street takeovers, donuts, or any boneheadedness out. Do you understand?
Yes, Your Honor.
If I find that you do this, I will take your privilege to drive away from you permanently, and you will be barred from driving. Same thing goes for you, Mr. Salazar. You are not to participate in any racing, street takeover, donuts, anything of this nature, reckless driving you do, I will take your privilege to drive away from you permanently. Mr. Varela, this is your second case. I am now taking away your privilege to drive away from you. You will now sign with me today an affidavit promising me that you're not going to drive. I don't care where you're going. I don't care what you're doing. I don't care what baby has to go to the hospital. You drive, I will have a contempt hearing. You'll be facing an additional 6 months in jail and a $500 fine every time you get in a car and drive. Do you understand?
Yes, Your Honor.
My only concern is public safety and every single person in Harris County. And when you do something like this, you put many, many lives in danger. You violate this, I'm going to violate you. Do you understand? For now, we are going to reset your cases to give you time to hire a lawyer. So I'm going to have you go to Victoria. We will have you sign a reset. After that, I'm going to have you take your seat in the jury box while we get your bond conditions. We will have you sign it, and then you will be on your way. You are going to come up here and swear to me that you're not going to drive. Mr. Varela, take note. I don't care what's going on in your life. I don't care what excuse you have. You cannot justify driving for any reason. And like I said, you do. You will be facing a stiff 6 months in jail. Every time you get into a car, it's an offense in and of itself, punishable. And I'm well within my right to stack it if you do. If you drove here, you may not drive home. Do you understand?
Yes, Your Honor.
All right. Come up here, swear to this. Gentlemen, if you'd like to go to Victoria, we'll have you sign a reset, and then we'll have you take a seat in the jury box. My question is, was there an affidavit of no driving on file?
I didn't check and I can't.
Now charged with reckless driving.
Yes, sir.
So I always order no reckless driving, no racing, no boneheadedness. Don't I, Mr. Mendoza? And now you've picked up a felony evading.
I can't access the district clerk right now for whatever reason it's not working.
I will tell you now.
Thank you.
There was a bond condition for you not to drive. Can you read to me what happened in the felony case, please?
Sure. Object. Officer of patrol, wait, yes, officer of patrol, observed vehicle drifted over a race on Canadian near the intersection of Buffalo Speedway and Holmes, and then attempted a traffic stop. The defendant vehicle fled at speeds of 100 miles per hour.
100 miles an hour.
Turned off its headlights, ran multiple traffic lights, and hit multiple curbs. The vehicle eventually came to a stop, and the defendant was detained. The defendant was obviously the driver.
I don't want to say obviously.
Guess what's happening now?
To this point, they're going to arrest you. Is that the case? Yeah.
Not only that, I will now have a hearing as to determine whether I should hold you in contempt. So, oh, do you need a translator? Guys, keep it down, please.
Good one to the judge.
Guess what's happening now, Mr. Mendoza? I ordered you not to drive. And what did you do? He goes with you. Okay, what is your name, sir? Lovings?
Page 25, 26.
Thanks. All right, Mr. Lovings, you're charged with indecent exposure and you're charged with evading arrest or detention. On the indecent exposure, you're facing up to 6 months in jail. On your evading, you're facing up to a year in jail. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during any questions and interviews with the state of Texas. If you cannot afford a lawyer will be appointed to represent you, sir.
Thank you, Your Honor. On July 2nd, 2024, officers met with the complaining witness who stated that she was cutting tree trunks at her home and noticed the defendant sitting on a bench near her residence. The complainant got her mail and then went into her car, and she noticed the defendant approach her car window. The defendant then proceeded to pull out his penis and begin masturbating. The complainant began to call the police. The defendant noticed the complainant on the phone and walked away. When officers arrived, they approached the defendant while in a marked Harris County Constable police car and wearing full uniform. The defendant then confessed to masturbating in front of the complainant to the officer. As the deputy went to detain the suspect took off on foot heading north on Lakeside Estates and then turned west into the backyard of the home. He evaded approximately 450 feet from the intersection. The deputy then deployed her taser and took him into custody. Your Honor.
Had to tase him to put him in custody.
Yes, Your Honor.
Mr. Lovings, I'm going to find that there's probable cause to go forward with your case. You're on probation for a very, very, very serious offense where you're facing a second-degree felony. The type of offense where if you were convicted, the offer start at 10 plus years. I would be very, very careful because now that you've picked up these two cases, it's very possible that they file a motion to revoke upstairs in the 263rd. Do you understand, sir? I'm now ordering you as a condition of your bond not to have any contact with the complaining witness and not to go within 1,000 feet of where she lives or where she works. Do you understand? Yes or no? Take it down. I can't hear you. I'm also going to put a GPS monitor so I know where you are at all times. Don't go near these people. Do you understand? Do we know that the felony court has notice of these charges now?
I tried to call the defendant this morning, Your Honor.
When's the last time you've had a full-time job, sir? Doing what?
That's what we came.
Why did you stop?
Because they had a new so they cut me off.
So how are you getting money to eat? Okay, it's time for you to get a full-time job. I am now also making that a condition of your bond as well. Do you understand, sir? When you have too much time on your hands, you become self-destructive, Mr. Lovings, and the time now is killing you. So it's time to get a job. I'm also ordering you not to be in possession of any weapons as well. I will provide you a lawyer today so that you can speak to someone about these cases. And I'm telling you, you best be on the lookout. It's any moment. They're going to file a felony warrant on you for your probation case upstairs. Give me any questions, sir.
No, sir.
I'm not going to talk about the case. I've got a bunch of DAs here. Anything you say, they can use against you. Hey, do you have any other questions? Okay. Would you like me to provide you with a lawyer? You're going to go hire a lawyer. Okay. So for now, I'm going to have you go to Victoria. We're going to have you sign a reset. After that, I'm going to have you take a seat in the jury box while we get your conditions with pre-trial. Don't mess these up. You understand? Because if I find that you act like you're like a fool in the free world, I'm going to take the free world away from you. And chances are, you said you live with your mother. Does your mother work or no? What does she do? Are you mom?
I'm mom.
Come on up.
Hi.
Hi, Mom. Thank you for coming.
Hi, Your Honor. My name is Tahita Lovings, and sorry. And he does live with me.
Let's not talk about the case. Did you hear what happened?
Yes, sir. Yes, sir.
You heard everything?
Yes, sir. We are in the process of working to obtain a lawyer, and we just wanted to get a reset today. And I've already notified the probation of what occurred on last week.
The first thing you need to do is just talk to a lawyer first. I wouldn't do anything else, but because, you know, right now, damage control, and the best thing that you can do is just talk to a lawyer.
Yes.
If you have any issues, I'm happy to give you a lawyer today, you know, because I know it's going to be a financial strain for you, and I don't know what kind of resources you have, but.
Yeah, I'm able to afford it. I work for a multinational beauty company.
Okay, so I have put strict bond conditions on him. I have put a GPS monitor on him. I told him not to go back to the location that he was, not to be in possession of weapons.
Okay. He will not.
Okay, is there anything else you would like me to add to?
I just want to make sure that because of his autism, that I have the opportunity to stand with him and because of his understanding and things of that nature. But outside of that, no, sir.
Okay. Is he able to obtain a job? Do you think he can?
He actually, my friend is opening a bakery in September, so she already agreed. Like the day that this stuff happened, she had come by the house to talk to him about a job.
And I think that that would be good. As I was telling Mr. Lovings, that too much time he becomes self-destructive. And then I don't know if that's what's happening, where he's just not keeping himself engaged enough with other things to keep him out. You know, I would be careful because like I told him, he's on probation for a
Yes,
very
sir.
serious case. And so,
Yes, sir. And we were right in the process of getting that tried to early terminated, but yeah, I got the attorney.
I'm with you. If you ever need anything, just come back to us, let us know. We can help you as much as we can. But so for now, I'm going to have him go sign a reset, and then I'm going to have him take a seat in the jury box while we get the bond conditions. We'll have him sign it, and then you guys will be free to go.
Okay.
Tracy, you can waive the fee, please. Okay, waive the fee. Okay. All right. Good luck, Mr. Lovins. Jonathan Mueller. Mr. Mueller, you're charged with racing on the highway. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Oh. 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 Oh.
Judge, counsel sent me an email saying that he was without power and,
Who is counsel?
Clay. Eric Clay, he's on the original case that he's on.
Does he have a phone number so I can call him, perhaps?
You can try,
Let me call him.
Judge, he said he had a lot of damage to his home. Do you want his phone number?
I got it right here.
Okay.
Is it the 281-435?
That's what I have, yes.
Eric Clay's office, Christina.
Hi, this is Judge Fleischer in Court 5. Is Eric around?
No, I'm sorry, he's not. We have notes, sir, but I'm in an area. I'm sitting right now at McDonald's.
Does he have a cell phone that it can make a call to us?
It's forwarded over to my phone, and he doesn't answer it to my phone.
Okay, I guess I'm going to appoint someone in the interest of justice to this gentleman because I have to do probable cause and he's picked up another case while he's on bond. So,
Who is that?
Mr. Mueller, this is
Okay.
Jonathan Mueller who's picked up another racing case.
Okay.
So,
No problem. I'll let him know.
you know, and yeah, if you want, did you get my phone number from this? Don't say it out loud though, but did you get my phone number?
Yes, sir, I did.
Okay, you can give him this. This is my cell phone. So you can, if you want, I can put this off for like an hour to give him time. See if he wants to try to call in.
Okay.
Um,
Let me try. I'm gonna do my very best.
No problem. Just, that's all we can do. So if you want, I can put this off for an hour and just get back a hold of me and then we can go from there. I'll just put it in the jury box for now.
That's fine. Either he or I will give you a call right back.
Great. Thank you, man.
Thank you.
Okay. Are you Jason Bryant?
Yes, sir.
Mr. Bryant, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You also have a gun case as well. On that one, you're also facing up to a year. Please don't say anything. Okay.
Thank you, Your Honor. On April 23rd, 2024, at approximately 2:30 in the morning, officers were dispatched to a crash call in Harris County. A witness stated that he arrived after the accident, where he observed the defendant sitting in the driver's seat of the vehicle with the engine still on. And then he saw the defendant get out of the vehicle and sit by a tree. Upon arrival, officers observed the defendant to be sitting under a tree near the vehicle, which was and he was being treated by the HFD. The defendant's vehicle was stopped with the right front bumper damage, windshield snap, the windows down, and the glove box open. Officers found a loaded handgun on the sidewalk with another magazine nearby and a single 9mm live munition near the firearm. Officers observed bloodshot, watery eyes, slurred speech, and a strong odor of alcohol coming from the defendant's breath. The defendant was unable to walk due to his injuries. The defendant admitted to driving, crashing, and owning the firearm, and he admitted to consuming alcohol. The defendant was transported to Memorial Hermann by ambulance. The defendant was unable to perform the standard field sobriety tests due to being in the hospital. They did not read the DIC-24 for the same reasons. But at about 5 in the morning, a blood draw was taken pursuant to a warrant. The blood test came back at 0.153.
How many DWIs does this gentleman have besides this one? This is a second. How many other?
This first one, it was a aggravated DWI liquor out of Alva, Oklahoma in 2012.
How long ago?
2012.
2012. Any other DWIs?
No, that I see, Your Honor.
Okay. Mr. Bryan, I'm going to find that there's probable cause to go forward with your case. Do you have a valid Texas driver license, sir?
Yes, sir.
Do you have valid liability insurance in your name?
I do.
I am now placing a restriction on your driver's license. You're not allowed to drive any vehicle that doesn't have an ignition interlock. If you're caught driving a vehicle that doesn't have an interlock, I will revoke your bond, put you in jail. You will not get any more PR bonds. You understand?
Yes, Your Honor.
Likewise, you're ordered not to consume alcohol or drugs. We're going to randomly test you. If I find that you're consuming alcohol or any kind of illegal substance, likewise, we'll revoke your bond and put you in jail. No excuse. I don't care where the positive test comes from. I don't care if it's alcohol or tequila, lollipop, hair dye, cakes, candies, foods, gums. I don't care. Look at whatever you put in your body because there's no excuse. Do you understand?
Yes, sir.
If you have a drug or alcohol problem, you better address it because if you don't, and I see it becomes a problem, I will do it for you and I will put you in a treatment facility in the jail in a heartbeat. Do you understand, sir?
Yes, sir.
I see that you do have a lawyer. Good job on having a lawyer. Because you do, I will waive your appearance, but it's your responsibility to stay in touch with Ms. Pendant. If she tells me she can't get a hold of you because you're ducking and dodging phone calls, I will issue a warrant for your arrest. She'll tell you if and when you have to come back to court. For now, I'll have you go to Victoria. We'll have you sign a reset. After that, you'll get retraced for your bond conditions, and then we'll see you soon. And we'll have you just waiting back for your lawyer as well. Okay? Please.